All right. Good day, everyone. And thank you for joining today's Ask Me Anything, where we answer your questions about cannabis legalization in New York. We do this every Wednesday at 4:20 p.m. New York City time. I'd like to welcome back those of you who have joined us before. And for those of you who are joining us for the first time, I hope you'll make it a regular occurrence. My name is Jeffrey Hoffman, and I'm an attorney in New York whose legal practice focuses entirely on cannabis. If you would like to contact me, you can do that either here on LinkedIn. I welcome all connection requests, or you can contact me at my email address, which you see on the screen, info@420jurist.com, which I guess you might say makes me the 420 jurist. And as the 420 jurist, I will be answering your questions, roughly half of them from the list of questions I've gotten from previous Ask Me Anything sessions, and half from questions which you post in the comments here today. So if you'd like to ask a question, now is the time to do it. Do a quick disclaimer before we get started, and that is that I am indeed an attorney, but I am not your attorney, at least not yet. Though I do see a few of my clients in the audience today, so don't worry. You folks are, of course, still my clients. But for the rest of you, I am not your attorney, and today's event is not legal advice, does not create an attorney client relationship, and is, of course, not a solicitation to offer legal advice. And so, with that, let's get to the questions. And there's a good one that just came in via the comments. So we're going to start with that one. Do you need to be a New York resident to submit an application? And the answer to that is no. And in fact, it does appear that having residency requirements on applications for cannabis licenses is possibly unconstitutional. There is currently a case up in Maine where Maine had a residency requirement to be able to get a license in Maine's medical cannabis industry. And some folks sued and they won in district court. That is, the federal district court in Maine determined that it was indeed unconstitutional for Maine to have that residency requirement. That ruling is currently under appeal. However, I will note that after that happened, Maine chose not to implement a residency requirement, at least that is my understanding, for their adult use cannabis or recreational program. So I think that gives you a pretty good idea, if you like to read the tea leaves, of where this is going to be headed. Additionally, the like I said, this is on appeal to the circuit court, federal circuit court. And if you just read what was going on with that and tuned into what some of the judges are saying, it does not feel that they are not terribly impressed with Maine's argument as to why they need a residency requirement. So I do think that residency requirement is going to go by the wayside, at least as far as that circuit court is concerned. Now, here in New York, there are a variety of criteria, and I see Miss Day has listed some of those criteria in the chat. So there are going to be various criteria that you can meet in order to qualify to be an applicant for a cannabis license in New York. The one that I think is perhaps the best for businesses. We attorneys like things that are called safe harbors. Very often in legislation, you will actually see a specific safe harbor outlined in the legislation. And basically, if you, as someone that's trying to do whatever the legislation is talking about, if you engage in one of those safe harbors, you're good to go. You don't really need to worry about anything else that they say is a way you can qualify or meet the means of whatever is being discussed. So my favorite safe harbor, I think, in MRTA, the legislation that legalized cannabis, is that the entity that holds the cannabis license is incorporated in the state of New York. There are some other ones, such as how many of your shareholders and a few other things, other ways you can qualify. My concern with the shareholder one is, let's say you had 5 shareholders and 3 of them lived in New York and 2 of them lived elsewhere. And then all of a sudden, one of your 3 that lived in New York decided they were tired of the winters here in New York and, they wanted to move to Miami. So then they're a resident of Miami, and you now have less than half of your shareholders who are residents in New York. So you have what we call a problem, not a problem you want to have in the middle of operating your cannabis business. So for these reasons, I just really think the safe harbor of incorporating the business in the state of New York is really the way to go. But I'm sure there are people that would want to argue with me, and that's what the legal profession is all about. All right, let's move on to a few questions from previous sessions. Good one related to what's going on right now, actually, with licensing and what licenses aren't available. And the question is, what is the immediate future for distributor licenses and the wholesale market? All right, so just to unpack that a little bit, the distributor's license is one of the 3 what I call upstream licenses: the cultivation license, the processing license, and the distribution license. And it is really the distributor that you're going to consider the wholesaler in the cannabis market in New York. Generally, most dispensaries and most on-site consumption lounges and most delivery guys, we're going to keep our fingers crossed and see if they get to be able to have their own inventory. But if they are able to have their own inventory, the vendor that those 3 types of retail licenses would get their product from would be the distributor license. And in addition, the potency tax here in New York, that is the amount of tax that needs to be paid based on the amount of THC in either your flower, your concentrate, or your edibles. This is the tier where that would get paid. It would get paid on the transaction between the distributor and the retailer. And again, that makes the distributor, if you will, the wholesaler who is paying the potency tax or wholesale tax, if you will, within the New York State market. So where are we with distributor licenses currently? And the answer to that is nowhere. The distributor licenses is one of the 9 standard licenses, which we are still waiting for regulations from the Cannabis Control Board. Hopefully they will drop those soon. My math is that it's anywhere of a minimum of 3 to 4 months after they drop their initial proposed regulation before we could possibly see an application for those 9 standard licenses. So if they want to get the application for those licenses started here in 2022 and open those businesses early in 23, they need to get their act together here and get those regs out pretty soon here this summer. But anyway, what is possible as far as distribution? As many of you know, we're going to have conditional adult use retail dispensary licenses, all of the justice-involved individuals in the DASNY spaces. The goal of the state is for those individuals to have their businesses up and running, or at least the first of them licensed before the end of the year. Where are they going to get the product? So the state legislature created a conditional cultivation license, and that is where those retail dispensaries are going to get their initial product. In that initial part of the law, at least until the middle of next year, those conditional cultivators are going to be able to minimally process their cannabis into products that are flower-based. So you can think of packaged flower and pre-rolls. The cultivators will be able to minimally process in that way and then distribute those products directly to dispensaries without a distribution license. Again, that is only going to be valid until the middle of next year. Additionally, the state just opened the applications for the conditional processor license. That opened right before July 4th weekend. And that license is where individuals or companies that were already in the state's hemp processing program will be able to get a license to process adult use cannabis. That is also processing for there to be flower or pre-rolls, but then all of the other great stuff, such as concentrates, edibles, the sauce, the rosin, the resin, hopefully a lot of good hashish, and of course, my favorite, the THC diamonds. Can't wait to get that. So those processors will also be able to distribute their products until the middle of next year. And then hopefully, because that's the way the rules work, nobody will be able to distribute after the middle of next year, except for their own product if they got a distributor license in addition to either their cultivator or processing license. And again, that will be limited just to stuff the cultivator cultivates or the processor processes. But the distributors that are going to be able to distribute anybody's cannabis products, and I think those guys are by and large going to win in the market. It's going to be awfully tough to compete with them if they're able to distribute everybody's products and you're only able to distribute your own products. But it'll be interesting to see how that works out. That license is one of those 9 standard. So again, roughly 3 to 4 months after the Cannabis Control Board releases their initial proposed regulations for the distribution license, we ought to see an application for that distribution license. Now, the fudge factor is in between the 60-day initial comment window and the 45-day revised rulemaking period, and I do believe we will use both for many, if not all, of the standard licenses. There is a period in between the 60 and 45-day period where the Cannabis Control Board can take pretty much as long as they want to decide what, if any, changes they're going to make. And again, I think they will make changes when we get to those licenses. So it'll be 60 days, some unknown amount of time while they figure out what changes they want to make, and then another 45 days. So I'm kind of saying 3 to 4 months if that intermediate time period is reasonable. For those of you that are keeping track of the conditional adult use retail dispensary license, the 60-day window ended for that May 31st. For those of you that are familiar with electing popes at the Vatican, they send out black smoke when there's no new pope, and then they finally send out white smoke when there is a new pope. We've gotten nothing but consistent streams of black smoke from the Cannabis Control Board. It's going on 36 days, I now believe. That's a pretty long time in this decision-making period in the regulatory review-making process. At some point here soon, they're going to tell us what they're going to do, and I do believe they're going to make some changes. We then have the other 45-day period, and then that application will come available. That's just to give you a little bit more color about what's going on with some of the other licenses. But again, to exactly what was asked from the questioner, that distribution license, the conditional cultivators, conditional processors will be able to do distribution until the middle of next year. And then whenever the distribution license gets released, off we go. And we're going to have a whole fleet of distributors across the state distributing everybody's cannabis products. Cannot wait for that to happen. All right, let's do, I saw there was another really good question, I think, that was related to that. As far as an interest in the taxing tier. So how does the potency tax work with the micro license? Very interesting. So the micro license is the one license that's going to have to be fully or that can and will probably have to be fully vertically integrated. I mean, I guess if you got a micro, you could just grow and not do anything else, but that doesn't seem to make a lot of sense. If you're going to get the micro license, you're probably looking to do everything you can do as the micro. The micro is going to have to meet the requirements of every one of the other standard licenses that they are doing the activity of. So if as a micro, you are going to do cultivation, by and large, you are going to have to meet all the rules that a normal cultivator will meet. If you're also going to process, you're going to have to meet all the rules that a normal processor will meet. If you're going to sell at retail, you're generally going to have to meet all of the rules that a retailer will meet, other than having to have where you do your selling be in a store. And if you just look at the retail part, it does say that retail dispensaries have to be in a store. And at the beginning of that section, it says specifically that that's not necessarily true for the micro guys. So who knows what their store regulations are going to look like. I'm sure we'll see much more from the Cannabis Control Board once they propose the regulations for the micro businesses. What we do know, and what was asked in the question, is what about the potency tax? And again, since the micros are going to have to behave just like each of the places where they want to do it, if they are going to do distribution to a retail dispensary or to an on-site consumption lounge, which it seems fairly clear to me that they will be able to do, they will collect the potency tax in that transaction. So if you want to look at it, that wholesale transaction between the micro business and the retailer, be it a dispensary or an on-site consumption lounge, the micro business will be responsible for collecting the potency tax at that step. All right, let's go back to a question from a previous session. And this comes, I think, out of, we talked a little bit in one of our previous sessions about the proposed marketing and packaging regulations that the Cannabis Control Board has put out. And for the record, I believe that what they have released so far is incredibly draconian. I would be surprised if there aren't changes. And frankly, if there aren't some changes liberalizing it, you know, but I've been surprised before. So we'll see what's going to happen. So, would I spend a lot of money building the visuals of your brand now? I would not spend $100,000 with a branding agency doing your branding work now. And if you're spending that much, you may need to find another branding agency. You can get very high quality work done for a lot less money. That's not to otherize branding agencies. They do amazing work. I just want people to be very careful about when they talk to any vendors in this space about the price they want to charge you for the quantity of work. I've seen places, I've seen brands try to really snooker social and economic equity applicants as far as the contracts they want to do to be partners with them. And I've definitely seen lots of people get ridiculously overcharged for all kinds of work, not to call out branding particularly, but just be very careful when you talk to your vendors and make sure you're getting good value for your money. But so I wouldn't go spending a ton of money if you are designing your own brand. I don't think it could hurt you to do some work on it. I don't think it could hurt you within the framework of what we currently know about the marketing regulations to do some exploratory work. Money, so that, I have friends that like to gamble in casinos, and as they tell me, and I hope it's true, they only gamble money they can afford to lose. And that's kind of how I would describe building your visuals at this point. If you are going to do anything, I would keep it well within the bounds of what the current marketing and advertising regulations say. And again, so don't necessarily do nothing, just don't go crazy yet. I do think and hope that there is going to be some liberalization to the rules that we have seen. One of the ones that I've talked about previously in one of my LinkedIn posts is, if you're familiar with George Carlin's, 7 dirty words that you can't say on television, which, by the way, was the root of a Supreme Court case, if you can imagine that. It's fantastic. We kind of have now the 5 words you can't say on cannabis advertising. Unfortunately, the 5 examples they gave, and it's not limited to those 5 examples. They simply gave 5 examples so you would kind of know what we're talking about. But, words like chronic and sticky buds, I mean, I 100% want to see the word sticky buds in advertisements in New York and on products that I buy. So I hope they make those changes. I think for an enterprising First Amendment lawyer, there's probably a good case to be had there. But really, what we've seen so far in New York has been fairly draconian. And I do hope that they change this. I get we don't want to encourage anything that does, 21 or under being incentivized somehow to be more excited about getting cannabis. I mean, I don't really know how much more advertising cannabis needs for folks to want to do it, but I get what the Cannabis Control Board is trying to do there. The flip side to that is that, from my perspective, and again, if any of you are in the alcohol industry, I'm not trying to otherize that industry, but I mean, if you want to talk about which industry, the cannabis industry or the alcohol industry, is more destructive on our society, I mean, the data is pretty clear. We don't have tens of thousands of driving under the influence of alcohol deaths because the alcohol industry is not destructive on our society. Yet we see alcohol ads on television everywhere. I see alcohol ads everywhere I go. I see alcohol ads in magazines all the time, right? So my perspective, honestly, is that cannabis advertising should be no more strict than alcohol advertising. So I would like to see the state of New York go one of 2 ways. They can have the draconian advertising regulations that they currently want to have on cannabis if they will go back and pass laws to have similar draconian advertising regulations on alcohol. Likewise, if they want to keep the advertising regulations that they currently have on alcohol, I would like to see the cannabis regulations be fairly similar. And that's all we're going to say about that. All right, let's go to the next question. And the next question is, what will food and beverage restrictions look like for social consumption licensees looking to open lounges? What challenges will a restaurant concept offering infused meals face when trying to win a license in New York? All right, so 2 different questions there, and they really are 2 different issues. As dealing with the first one first, what will food and beverage restrictions look like for social consumption licensees looking to open lounges? So, The cannabis lounges themselves and the smoking of cannabis in the cannabis lounges is governed by MRTA and the Cannabis Control Board. The serving of food in an establishment is generally governed by the health department and the rules in New York Code related, obviously, to restaurants and serving food and all of those types of things. So the bigger challenge here I see really than anything that we know at this point is the fact that you're going to need to be, if that comes to pass and you want to do that, you're going to need to be regulated by two different entities, both the Cannabis Control Board for the cannabis that's happening and by the health department for any food that's getting served. Now, unless I've missed it, and please weigh in, folks, if you think I've missed it, because it's possible, I have not seen any restrictions as far as food at on-site consumption lounges at this point. In fact, some of the ones that are opened in other states do allow both the cannabis and the food. So nothing that I've seen so far would make that impossible. I do think that it would not surprise me if in the fuller regulations that we get from the Cannabis Control Board about the on-site consumption lounges, if they do mention something about food or how that is all going to play out. But just again, at this point, I do think you'll see regulation. My bigger concern at this point would be the fact that you're going to have two different bodies of regulatory law that you're going to have to deal with and two different regulators that you're going to have to deal with. And usually in any business, one is enough. So if you want to deal with both, Godspeed, John Glenn. The next question was, what challenges will a restaurant concept offering infused meals face when trying to win a license in New York? Now, that is a bit of a deeper issue. That is something that, again, I think you're going to have to deal with both regulators. I see Mr. Rivera just said there are places that serve infused foods here in the Bronx. All due respect to those places, Mr. Rivera, they are breaking the law. They are acting completely illegally. And, if I were them, I would be quiet about it and carry on their business. I wouldn't get in the New York Post about it. But any of that activity currently is 100% illegal. But what challenges will a restaurant concept offer for the infused meals? Again, you're going to have to deal with two regulators. You're going to have to deal with both the health department and the Cannabis Control Board. There has been discussion about this. This is actually something that was and probably still is in active discussion in the Office of Cannabis Management, and it wouldn't surprise me again to see something about this in the eventual regulations that we see from the board. Back in April is when there was a real big burst of activity about this. If you want to Google it, in the New York Post, there was an article entitled "New York Ways Giving Pizza Joints Other Eateries Okay to Sell Cannabis-Infused Food." So look at that article in the New York Post if you want to take a look at it. And again, it does seem to me that this is something that is very actively in discussions about this. And I think it would be great. I would certainly do this. I just, some people are not able to properly process cannabis as an edible. I'm actually one of those people. My good friend Nikki Lawley, the queen of medical cannabis here in New York, she also seems to have this condition. We talked about it a lot, that neither of us are able to get off on edibles, and I actually, frankly, never understood why. And thank you to Nikki for letting me know about that. Really interesting info. So I'm all for the cannabis lounges serving food, and for that matter, in serving infused food. But unfortunately, I don't think it would have an impact on me. So that would be unfortunate. All right, I got about 6 minutes left, and there was a really neat question that came in last week that really touched on a lot of issues, and I wanted to do some research into it because I really wanted to have a good prepared answer. This is not one that I think maybe I could have just on the fly in an AMA, but I went and got the definitive answers to a lot of these things. And what I really like to do when I have this level of specificity is that I do like to just kind of read exactly what MRTA says related to this issue. So let me ask the question, then we'll read through it, and then off we go. And the question is, are retailers or producers permitted to offer rewards programs to consumers, Are producers restricted from creating relationships with retailers? And what are the limitations on promotional advertising by the producers? So, unbelievable number of issues to be unpacked in those questions. We could probably have a whole half-hour session just on those 3 questions. But what I did want to go ahead and do is kind of give you a color of what is going on in the law, what seems to be going on in some of the regulations, and to just give a feel for what is going on, excuse me, around this question. So the first thing that I want to do verbatim and read to you verbatim from MRTA is deals with cultivators and processors. And here's exactly what it says. No cultivator or processor of adult use cannabis, including an adult use cannabis cooperative, microbusiness, or registered organization, may offer any incentive, payment, or other benefit to a licensed cannabis distributor or retail dispensary in return for carrying the cultivator, processor, cooperative, microbusiness, or registered organization's products or preferential shelf placement. So let's unpack that very importantly. So we're talking about who is restricted there. The people that are restricted are the cultivators and the processors. Okay, that's who is restricted here. And that includes the cooperatives, a license nobody seems to be talking about, who can act as cultivators and processors. The microbusiness, who, as we just talked about before, can act as cultivators and processors. And the ROs, the registered organizations, the medical guys here in the state. So none of those entities can offer an incentive, payment, or other benefit. And that last one, other benefit, is the catch-all. That means pretty much anything. You cannot, in effect, bribe, and not just bribe, but even just say, hey, we'll take you to the Yankees game if you'll carry this product instead of other products. So you can't do that. In return for carrying their specific products or for what is known as preferential shelf placement. And for those of you that have ever shopped in a supermarket, which is all of you, in that industry, it is the standard of the industry that the manufacturer and the distributors will pay the supermarket for shelf placement. They will say, carry our product to the exclusion of these other products and put ours in. And very often it's at the front of the aisle, right? So how does the brand get that very front of the aisle, really good placing in the supermarket? Easy, you pay them. So this shelf placement is not allowed for the cultivators or the processors to make deals with those guys to do that. Additionally, so people will say, well, what about the distributors? Here's what we know about the distributors. No distributor shall provide any discount, rebate, or customer loyalty program to any licensed retailer except as authorized by the board. Okay, so what that means is today, a distributor cannot do anything. No discounts, no rebates, and no loyalty programs to the retailers. Again, this is the wholesale transaction we're talking about, not the retail transaction. So at that wholesale transaction between the distributor and the retail, no discounts, no rebates, no customer loyalty programs, unless such a program is authorized by the board. So my guess is that you will see in the regulations that are forthcoming for distributors what, if any, types of whatever you want to call it, rewards, rebates, whatever you want to call it, that can happen in that wholesale tier between the distributors and the retailers. All right, next one, which again is in MRTA, the law. No cultivator or processor or distributor of adult use cannabis shall furnish or cause to be furnished to any licensee any exterior or interior sign, printed, painted, electric, or otherwise. They, for whatever reason, needed to say what kind of signs, and they get otherwise, which is every kind of sign, except as authorized by the board. Again, that except as authorized by the board, which is the let out of jail card. So, as we stand today, cultivators, processors, and distributors cannot give or make or create any sign for a retailer. Eventually, again in regulation, I do think the board will enable them to, but it'll be limited to whatever the board can say. Those of you, again, that are in the alcohol business or who have ever gone to a bar or shopped in a liquor store or in a grocery store all of those neon signs and all of the signage that you've ever seen for an alcohol company, for a brewer or a distributor, mostly for the brewers, of course, those signs are actually not owned by the bars. Those are typically signs that are leased or sold, or with a buyback or something, by the manufacturer to those bars. So this is what one of the things we've talked about in previous sessions is that a lot of the cannabis law is based a lot on the alcohol law. And here's one place where they're making a pretty dramatic difference. At least right now, none are allowed. It's a similar. You can't do certain things in the alcohol business. Again, here in the cannabis business, they'll do similar things where they'll say what you can and can't do. Again, based on the draconian nature of what we've seen so far in the advertising and marketing regulations, I do expect those signage things to be pretty draconian. And you'll be able to, just like the advertising in alcohol, be able to get away with a lot more in the signage in the alcohol world than you'll be able to get away with in the cannabis world. Moving along, dealing with the retailers, no sign of any kind, again, printed, painted, or electric, advertising any brand shall be permitted on the exterior or interior of such premises, and this is in the retail dispensary section, so that's what we're talking about, except by permission of the board. Now, for those of you who may be familiar, we do have some proposed regulations from the board, and the board says that when you do your advertising, you're limited to 2 signs. They have some other requirements as far as how big the signs can be and where they can be and where they can be seen from. So you can't be seen from a school and various other places. But again, this is something that was in the within the law, and this is where they're going with it. And then finally, in the advertising, so everything that I discussed above is in MRTA. So those are laws. As you saw from most of them, there are things that the board is going to be allowed to authorize, and I do think you will see the board authorize those things, and they will be coming in the forthcoming regulations from the Cannabis Control Board. The last thing that we're going to mention here is in the proposed regulation that the board has proposed for the marketing and advertising, and that, going to read it again for you verbatim, no marketing or advertising of cannabis products shall promote price reductions, or any discount, customer loyalty program, or coupon. And again, unbelievably draconian. Now, whether or not you can have a loyalty program and whether or not you can market a loyalty program are the same thing is a very good question. I do think probably in the final regulations, they're going to say no loyalty programs. If you can't market it or advertise it, kind of what good is it? But I do think there's that slight opening in the marketing and advertising regs that maybe you can have it, but you can't tell anybody about it. I don't know. We'll see. My guess is in the actual regs for dispensaries, they're going to say no loyalty programs. I know many other states do have loyalty programs. I, for one, love loyalty programs. I'm going to buy a lot of cannabis products, so I would love to be getting free cannabis products for all of the cannabis products I'm going to be buying. So I would love a loyalty program. I would love coupons, but right now, again, very, very draconian marketing and advertising regulations from the CCB. I really hope they loosen them up before the regs become final. All right, we went a little over today. Hopefully everybody got a lot out of the session. I want to thank everybody for joining. As you know, we do this every week, every Wednesday at 4:20. Would love to have you join us again next week. If you're not currently a connection of mine on LinkedIn, by all means, send me a connection request. Would love to connect with you. And as I say every week, the most important thing that's happened in our cannabis industry are the justice issues. People being able to get their cannabis convictions expunged, getting everybody that was ever convicted of a cannabis offense, a nonviolent cannabis offense, out of jail, and making sure that everybody knows about this stuff. It's very important that if you know that your conviction was expunged, you no longer have to check the yes box when they ask, have you ever been convicted of a crime on housing and job applications? Generally, you can't do that in New York these days anymore, but if you move to another state that does ask that question and your conviction has been expunged in New York, you no longer have to check the yes box. Thank you, everyone. Have a great afternoon, and we'll see you next week.